Hi, everybody. Welcome to Trial Alchemy. And today I'm delighted to have as my guest Craig Peters from up in San Francisco. Craig is the founding partner of Altair Law in San Francisco. He's a plaintiff's lawyer and he handles high value personal injury and wrongful death cases and also co-counsels as trial counsel on cases as diverse as civil rights, consumer rights, landlord tenant disputes, business disputes, toxic exposures, and insurance bad faith and medical malpractice. And Craig and his team have achieved some of the largest verdicts and settlements in California, and in some cases, the entire United States. Craig is a member of the American Board of Trial Advocates. He actually currently serves as the National Treasurer of ABOTA, and he also serves on the National ABOTA Board of Directors. Craig is also a member of invitation-only groups, including the American College of Trial Lawyers, the International Academy of Trial Lawyers, and the International Society of Barristers. So without any further ado, Craig, thanks for being a guest here today. I'm delighted to have you.
Thanks for having me on, Monty. I appreciate it.
Well, let's go next to the idea of trial themes. Now, you may use similar themes in a lot of your cases, but you may mix it up. So what are some trial themes that you have found work really well for you?
Yeah, so I used to be huge on, coming up with themes and slogans for my cases, particularly back when I was a criminal defense lawyer. I've done it a lot as a plaintiff's lawyer as well. I do it less now than I used to in terms of having, something catchy.
Well, good. Explain why too. Yeah.
Sure. Yeah. Profits over people is always a good theme if it's applicable. And certainly that may come out during the trial if I do a lot of products cases. And so that's a frequent area in which that will come out.
Right.
I like to say that, a trial isn't about the facts. The jury, again, if we sort of think about the case from their perspective, you've pulled 12 people in from the street and stuck them in a box inside of a courtroom that's this kind of intimidating place. Right. And then a bunch of orders and rules have been barked at them, most of which they're not really digesting yet because they're still thinking about their family, their work, their, boyfriend, whatever.
Exactly.
And then the lawyers get up and give these amazing opening statements, that tell them that, this is a roadmap and, this is what you're going to hear, and then give them, 1,000 facts for the plaintiff and 1,000 facts for the defendant. And then they proceed to have a trial where witnesses go on and tell them information. Sometimes it seems maybe like it's related to the opening statement, but maybe it's not.
Yeah.
Right? They're not really sure. And they're trying to take notes, but they don't really know. It's kind of like you've handed them a basketball on a basketball court and said, play basketball, but you haven't told them what any of the rules are or how you score, right? They don't know any of that stuff.
Good
and
point.
we forget that sometimes because we're so used to it. And so, the beauty of themes and slogans is it creates an anchor that, the jury can be tied to again and again and again that helps them remember what the case is about. That's super useful. But the case isn't really about the facts because they don't know what facts are important or not unless you have a judge that at the very beginning gives them the jury instructions for the elements that have to be proven so that they now are oriented to what they need to know, which, by the way, I advocate for. I think that makes a lot of sense. It's a lot more fair to the jurors to do that. But that's not the norm, at least in California.
Right. You don't get a lot of judges saying yes to that.
No, and it's odd to me because to me it just makes such fundamental sense. But in any case, it's that's not the norm. So if the case isn't about the facts, then what's it about? It's ultimately about who can the jury trust. They are looking for somebody to trust in the courtroom.
Right.
They will trust the judge, no matter how good or how bad the judge is. My experience has been they will trust the judge, but the judge isn't giving them facts or making a case for one side or the other. So I feel like our job as the lawyers is to be, despite what you see in politics these days, where a politician can say the same lie 50 times and get called out on it 50 times and keep saying it and people will believe it. That's not how it works in a courtroom.
Right.
You know, in a courtroom, if you lose credibility once, enough jurors are going to know that they're going to start to discredit what you have to say. So our job as lawyers in a trial is to build our credibility with the jury so that they know that we are an honest broker that they can trust. Sometimes I think themes and theories and slogans can get in the way of that. And so I have moderated my approach somewhat, that if I'm going to use one, I might use one once in opening, and I might use it again a couple of times during my case, but I won't beat the drum like I used to with a theme or theory or a slogan, because I think it actually can be counterproductive to building that trust with the jury. I am a big believer. One of the big things I learned as a public defender, was about bad facts. Turns out as a public defender, you sometimes will get cases that have bad facts.
Amazing.
In fact, every case has a bad fact, which is that your client has been arrested and charged with a crime.
Yeah.
And jurors tend to think that means something happened. And our motto in the public defender's office, when we talk about cases and, what are the facts and how we're going to deal with them, was whatever our bad facts are like bad fashion. Don't try to hide it. Feature it. You got a bright neon pink boa. Don't try and tuck it under your jacket. Wear it right out there. Put it right out front. Right. Because if you put out front the bad facts, it does two things. One, it takes the sting out of it. It doesn't appear to be as bad because you, the person who it presumably is harmful for, is the one that's bringing it to the jury.
And you're not trying to hide it.
You're not trying to hide it. And number two, it tells them you are an honest broker. Yep. You are not going to try and shade the truth or hide things from them or skirt issues or avoid issues. You'll deal with it all, because ultimately you're not only telling them you can trust me, what you're telling them is I, the trial attorney, I trust you. And so, themes and theories are good. I think they're a good way to think about your case, to kind of crystallize in your own head what the case is really about.
Right.
But I spend less time with them now than I used to, particularly in weaving them through my cases, because I'm more focused on figuring out ways to earn the trust of the jurors through the course of the trial.
Well, I think that's a really good evolution in your thinking. I mean, in my experience in trying cases just like yours, credibility is the most important thing. Totally. And as you say, the judge will be presiding and they trust the judge, but they're going to have to believe one of those attorneys. And if they don't believe you or they don't believe your client, you're in big trouble. So I've always thought credibility is the most important thing. And it's not just I think it's not just being honest and being straight with them. There's also a likability component, so that if you're honest and straight with them, but if you're this is the ABOTA thing. If you're a professional, courteous person, and your opponent is not, and so often that's true too, that helps your credibility.
That's right.
Just being courteous and just being respectful, that kind of stuff. I mean, I had one
patient.
Yeah, and you got to be patient. I mean, I had one of my thoughts that I always used to have in trying cases was, well, nobody's going to ever out nice me. At the worst, it'll be a draw. But if they're not able to be polite and courteous, that's going to help my credibility. Mm-hmm. And I think it really does. So I think that's a great insight. And so you don't use the themes as much. You may still use them a little bit, but not as much.